Good morning, everybody. Welcome to WG University. This is the Weber Gallagher series of educational webinars, and today we're going to be doing another webinar on workers' compensation in New Jersey. We do one a month here and one a month in Pennsylvania as well. And my name is Jeff Newby, and I'm one of the partners at Weber Gallagher, and I work here in our Mount Laurel, New Jersey office. And today we're joined by my partner, Rich Arnold, who traveled down from the Warren office.
Morning, everybody.
And Rich is able to join us today. Thank you for making the trip. So what we'd like you to do is be aware that these webinars can be found on our website at WG University Programs. Just go to our website at www.wglaw.com, and if you find, you look for WG University Programs, and you can review this again. You can forward it to other people as well. So today's presentation is course and scope of employment, key facts to access and assert for your defenses in New Jersey. If you have any questions at any point during the day, please send those questions to questions@wglaw.com. And Rich and I will get back to you with our answers before the end of business today. So let's get started. We're going to talk about course and scope of employment issues today. It's probably one of my favorite topics and one of the topics that comes up most frequently about trying to assess compensability and whether or not to pick up a claim and pay benefits on it. And the way we're going to deal with the approach, let me move slides forward, slides. Try this. There we go. Okay. We're talking about the injuries both. First, we're going to start with on-premises injuries, and then we're going to focus on off-premises injuries. And we'll take it that way so you can try and focus on what's the law and what are the facts you need to be aware of. The on-premises injuries, they ordinarily occur during the course of employment. So it's the time and place where the injured worker is supposed to be when the incident takes place. So the question will be at that point, does the injury arise out of employment? It's going to be during the course of employment, but does it arise out of employment when it's on the premises? Some of the tougher cases are the off-premises injuries. And the question there is whether or not the injury occurs during the course of employment, and it's not as easily answered. And that's an issue of whether or not they are off-premises performing work for their employers. So let's start off with the on-premises injuries. And the first question we're going to ask under Section 36 is, has the employee's commute ended? Are they on the employer's premises and are they beginning to do their work and perform their work day? Because injuries while simply commuting, as you all probably know, are not compensable. Simply traveling to and from your employer's place of business, accidents that occur are not compensable. So the question is, when have you arrived at the employer's premises? We're going to give you some ideas and some case law on that. And the first exception and the rule we want to bring to your attention is called the premises rule. And this was really elaborated quite a bit in a decision about 20 years ago called Livingstone versus Abraham and Strauss. And the question there was, had the employee reached the premises of the employer when she fell in a parking lot in a mall? And in this case, Ms. Livingstone was required by her employer to park in a distant area of the parking lot, obviously leaving parking spaces closer to the front of the mall available for the customers. So the question was whether or not falling in a parking lot that was not owned by Abraham and Strauss, it was not controlled by them in terms of maintenance or anything like that. But the question was whether or not they controlled her commute, so her commute ended once she reached the parking lot. So the holding in that case was that she was entitled to benefits because the employer told her where to park, and as a result, it increased her risk of injury. She obviously has now a much longer walk to work. Instead of parking out in front, walking a few steps, she's walking, several hundred yards, and she's exposed to other vehicles, flying carts, the weather, the elements, etc. So greater risk of injury controlled by her employer. As a result, she got to work when she parked her car, not when she got in the mall, not when she got in Abraham and Strauss on the actual premises themselves.
We actually see this issue pop up a great deal because nowadays a lot of office buildings as well as strip malls and things, you have multi-tenants to buildings, and the question mark often arises as to who owns the parking lots, are there assigned spaces for it, who monitors it, who's in charge of snow removal, who's in charge of repairs. So parking lot issues pop up frequently in these cases.
Right, and they're very fact specific, so we need to know details regarding the facts. I had a case similar to Abraham and the Livingstone case And I was able to get a Section 20 settlement out of it because what I determined was, although the employee was told where to park, she parked right behind the back of the building, so she was exposed to no greater risk of injury. The judge felt that it was still a Livingstone case, but he appreciated the nuance of my argument that there was no greater risk of injury. She had just as an easy walk into the building, but she had to park out back, which was closer to her clock in, closer to her desk where she worked and all those things. So we were able to Section 20 the case and get it for a much lower dollar figure because of the leverage we have, because you have to know the case law. So the next case I want to talk about before I pass it off on to Rich is a more recent decision called Hirsch versus the County of Morris. This case was decided about 1.5 years ago, and until the Supreme Court got a hold of it, it was one of my least favorite cases. I even hated talking about it, so I would try and pass it off on to somebody else. In the Hirsch case, she worked for the County of Morris, and she was struck as a pedestrian while walking from a garage that was in a parking space that was paid for by her employer. The garage is about 2 blocks from the County of Morris, and the County of Morris, out of the goodness of their hearts, reached an agreement with the garage, and they got 65 free spaces for their employees. First come, first served, didn't have to use it. She could continue to park where she parked before she was injured, right behind the building, right behind the county's building, where she paid $5 or $10 for some parking. But they wanted to provide a benefit to their employee, and as I used to call this case, no good deed goes unpunished. They provide free parking. She could take advantage. She didn't have to take advantage. She did. And the judge and the appellate division both felt that the fact that they provided the parking in that garage was similar to the Livingstone versus Abraham and Strauss case, where they now controlled her commute. So from the time she parked in the garage until the time she got to the premises of the County of Morris, she was covered for that entire 2 blocks. So that was the issue up to the point it got to the Supreme Court. The Supreme Court fortunately held this was not compensable since the employee was not required to park in the garage. Rather, it was optional. Her trip from the garage to the County of Morris she had multiple different blocks. She could go left, right, different ways of getting there. She chose her own walk. And fortunately, they decided that when she was struck by this vehicle as a pedestrian, that her injuries were not compensable. And I think this is the start of a little bit of a trend of making these off-premises injuries a little bit more conservative trend and limiting some compensability, because we're starting to see some cases go pretty far afield, which we're going to talk about in a second. But the Hirsch case, I think, has put a halt to some of the liberal interpretations of Section 36.
And I think in some regard, while nobody can really establish this with certainty, the fact that Hirsch was against the County of Morris, I think, played a factor into it as well. For some reason, we see certain decisions where the respondent is a public entity and it appears to be public dollars playing. When those cases get to the Supreme Court, the decisions tend to run a little more conservative as to findings of compensability. So a lot of times those cases are better when they make their way up to the higher courts. Not always, but...
Yeah, no, I've seen that with some nonprofits that I've represented over the years, and they're well known and they do a lot of good service for the community.
And courts consider that to some regard.
Yeah, they get some better decisions. So fortunately, she was working for the County of Morris, so we got a good decision out of this.
And it applies to everybody, though. That's the important part.
Last case I'm going to talk about before I pass it off on to Rich is Novice versus Rosenbluth Travel. In the Novice case, what's interesting about Ms. Novice is she worked for Rosenbluth Travel in this area, but she was, at the time of her injuries, she was up in the New England area. She was working temporarily in an office where they were shorthanded. So, but she would get up there, let's say on a Sunday, and she would stay long term for a week or two. They provided her with the hotel. But once she got to the hotel, she was commuting to and from the office, the Rosenbluth Travel office up there, like she would be down here. Obviously, traveling to New England, she would have been covered. Traveling back from New England, she would have been covered. The question was, when she fell on a multi-tenant sidewalk walking into work that day, was she covered as a traveling employee? Was she covered as being on the employer's premises at the time that she fell? And the court said she was not. This was not a compensable event. She was, as I note here, she was assigned on a week-to-week basis, and while commuting each day to the office from her temporary residence, she was no more covered than any other employee that worked at that Rosenbluth Travel location. This was a multi-tenant parking lot. She wasn't told where to park, and they did not control that parking lot. It wasn't their sole ingress and egress. That the only people using it were Rosenbluth Travel. It was a multi-tenant building, so she had not gotten to work yet. So under Section 36, she was still commuting, and this was found non-compensable.
And as Jeff pointed out, that's because she was there on a week-to-week basis. If she had been coming from home that day and it had been her first day to arrive and just went straight to the office, You might have had a different result on that, I think, if she was coming straight from New Jersey to that office and just went straight to the office and fell. The court might have viewed that differently as still part of the special mission because she hadn't arrived yet to her new residence.
Right. Yeah, then she's furthering her employer's business interests while she's off premises, and it's not simply a commute.
Yes.
All right, Rich is going to talk about elevators.
So we talk about elevators. Now you've made it out of the parking lot and into the building. Now again, we deal with a lot of multi-tenant issues. So we have the Ramos case and the Piles case. In a lot of ways very similar in facts, but different as to the result. Ramos is not a case we like on the respondent side of things. Mr. Ramos was an employee on the 4th floor of a building for his employer, and Mr. Ramos's habit was to show up early every single morning, have his breakfast, have his coffee, and hang out by the freight elevator in the back. And the employer knew he did this on a regular basis. The day in question, the elevator was not where it should have been and the doors weren't closed, and Mr. Ramos fell down the elevator shaft and sustained significant injuries. When the court looked at this, even though the employer did not maintain that elevator and it was used by other tenants of the building, the court still looked at it and held the loss compensable because the employer in that case did use the elevator for moving their product and freight in and out of the building, and as such, the court expanded the premises of the employer to include the freight elevator. They found kind of a loophole in it to say, well, you use it in your furtherance of your business interests, so even though you don't control that elevator or maintain it, you in effect have expanded it to become part of your working premises. I call it the old rule of if it's tragic, it's compensable. Mr. Ramos did sustain significant injuries falling down that elevator shaft, and in that case, the court wanted to find a way to fashion it to find him benefits, I believe.
Yeah, that and the fact that you already mentioned he would come to work early.
Yes.
So he was a good worker, probably well liked by the employer, not a problem employee at all. But they really stretched the facts in the law to make this compensable because, frankly, calling the freight elevator an extension of the employer's premises was extremely weak and a very thin argument because, as you pointed out, everybody on the 2nd, 3rd, and 4th floor, all the other tenants also used that freight elevator to move their products. And Mr. Ramos used it to move himself. I've done that before. When I used to work in the Philadelphia State Office building, I would use the freight elevator to get to court if that got me there faster. I didn't care if there was tarp hanging from all over the place or if I was in there with a bunch of people with carts with pieces of wood or whatever. The dissenting opinion in the Ramos case, and we didn't put in citations or years. I don't want to clutter up the PowerPoints. It's from about 1998, this decision. And the dissenting opinion was so well written and very vociferous in their disagreement with the majority finding this compensable. But fortunately, what we're going to be talking about today is it seems as though those kind of liberal decisions were getting a little bit more conservative in the off-premises injuries, which is what Section 36 was all about anyway.
Yeah, we're trending back, which is more along the Piles decision, which is more in line with the cases we normally see with elevators. Freight elevators, Ramos seemed to expand the notion that if the employer uses them, you might have an issue of compensability, as opposed to what we'll call people-moving elevators. The general bank of elevators you'll find in most buildings, shopping malls, strip malls, that aren't used for the freight, but just for the people working or the customers coming in and out of the building. Now, in the Piles case, petitioner just that, had come through the lobby of a multi-tenant building and fell while exiting the elevator to come off on the employer's 3rd floor. The employer did not own the elevator, did not own the premises, did not maintain the elevator. It belonged to the building owner, so the person was not on the work site yet. In that case, they distinguish it from Ramos, and using that language, basically saying, well, this was a people mover elevator, there's not product involved into it, kind of a weak distinction, but nevertheless enough for them to say, we're not following Ramos here. If it's just people is a form of commuting. People are commuting at that point on the elevators to get to their offices, and therefore that is not a compensable loss. That's generally what I've found most of the judges hold when it comes to just general banks of elevators that are used to move people to and from buildings. Unless the employer has some control over the elevator or is responsible for maintenance of it, you are not on premises yet. The one exception that might apply to that, as I would see it, certain elevator banks in certain buildings open directly into offices. I've seen that happen before. There is a distinction that if the elevator itself opened directly into the office premises, not a common hallway, and the person tripped and fell and landed into the premises to get injured, I think you'd then have a different result as opposed to a common hallway.
Oh, I agree. We were talking to some clients yesterday, and they asked that question, and they occupy the entire floor. I think once you get to the floor, you're covered. In the elevator, you're still not covered as far as I'm concerned. But once you step out of the elevator, if right or left is your employer, I think you are covered at that point.
If it's a multi-tenant floor, different result, because then it's a common hallway at that point.
It made me just, you talking about the distinguishing factors between the two cases. It hadn't occurred to me, but it may occur to some of those, some of you folks out there listening. If you do have that option for your employees, whether or not it's a people mover elevator, and maybe there's one down the farther end of the bank that's a freight elevator, you may want to put in your employee handbook, only use the people mover. So give that a shot, and maybe you can limit some of your risk. Now, next thing we're going to talk about is we're going to focus on the off-premises injuries. So when people are away from, we're still going to focus on on-premises injuries, but we're taking away from the gray area of has the commute ended. So in these cases, the commute is clearly ended. They're on premises. Now the question is whether or not the disability or the claim is compensable because it occurred during work hours. It's not a question. It's not going to be a defense. It is during the course of employment. The question is, does it arise out of employment? So the first case we're going to talk about, this petitioner has pre-existing COPD. She alleged that she was exposed to perfume spray, and the facts in the case were it just wasn't, perfume from a colleague a few cubes down or in the office next door. Unfortunately, the co-employee sprayed a copious amount of perfume, like in the direction of the person with pre-existing COPD. So they kind of almost like got tasered with it, or the very, very noxious spray. Anyway, exposed to the perfume spray, went to the hospital from the employer's premises, and never returned to work. Completely disabled from there on in. So the question is whether or not her reaction, due to her pre-existing health issue of COPD, to this on-premises perfume spray, is that a compensable scenario? What's interesting about this is the judge that decided the case, I would have thought of as fairly liberal. And the judge dismissed the case and said this was an idiopathic or personal reaction to something that occurred during work hours, but there was not a risk associated with the job. It was a purely personal risk. Dismissed the case as non-compensable. The appellate division reversed that decision, found that the injuries were compensable. They did not believe that the pre-existing proclivity or reaction to the perfume as the result of her COPD was a defense, but rather that this was direct exposure at work, which aggravated a pre-existing condition, which ordinarily is certainly deemed a compensable event.
It was probably somewhat, as we like to talk about all the time, very fact-sensitive by the evidence presented in that case. The fact that this was not just somebody wearing perfume, this was somebody on a routine basis continually spraying it and everything else. It's not the norm that somebody might experience in their life outside of the workplace.
Yeah, it was definitely unusual. It was not, like I said, it wasn't just simply that it was perfume in the atmosphere. This person, and I think it was actually twice in the same day. So I don't know why someone would do that, but it's a joke, but it certainly did not work out well for the petitioner nor the employer who was going to pay her for the rest of her life. Next case we wanted to talk about, again, it's an on-premises injury. The petitioner stocked shelves for a supermarket chain, and she testified that she felt no unusual symptomatology performing her normal jobs or job duties. She had no pre-existing issues regarding her low back, and at the time her back popped. She was walking down an aisle at work when suddenly her back popped and she was seized with pain. And I like to call it, I have some phrases for some of these cases. I call this the honest petitioner case. This woman didn't gild the lily at all. She didn't say, I just finished a rigorous job duties of lifting tons of boxes that were heavier than normal. I wasn't walking more quickly than normal. I wasn't called suddenly by a co-employee or a supervisor to come back and assess an issue, and I turned on my heel and something popped. She admitted she had no symptoms, no prior issues, had just performed her normal job duties, and would not have otherwise had any issues or problems, but for her back suddenly popped while she was walking straight forward, carrying nothing in her hands.
And it does happen because I litigated a case almost with identical facts to that, with the difference of that about 5 minutes before he was walking across the floor, the gentleman had testified, and all the records seemed to establish he was moving a very heavy piece of machinery before that. Didn't feel anything at that time. And then about 5 minutes later, while walking across the floor, felt something pop into his back. And it didn't help that the treating doctor, when he looked at him, said it was probably something that happened when he lifted the heavy machinery and just took a delayed reaction to it. That was enough for the judge to look at it and say, okay, that's going to be compensable.
And that's how fact-specific these cases
Yes.
are. You have to get your facts and lay them next to the facts of the cases that have already been decided to try and decide which way we're going to go. Denied, compensable, provide medical care without prejudice while you're investigating it further to see if they have a prior issue that they didn't tell you about that's in their family doctor record, like that. So in this case, Fitzgerald versus Walmart, the question is whether or not her injuries were compensable because they clearly occurred during the course of employment, but was it a risk associated with her job? And the court said no. The injury occurred during the course of her employment, but it did not arise out of the employment. And that's the key phrase. If you're at work, does the injury arise out of employment? Is there any risk or work effort that gave rise to this? And according to her testimony, there was not. So it was completely idiopathic. It simply happened at work. So it's coincidental, time-wise, but there's no physical causal relationship.
And again, that's where the investigation really plays out into it to find out what they were doing. If you think you have a defense of this nature, it's important to find out what the person had been doing prior to this thought to be idiopathic event took place. I had one of these years ago. I'll never forget the case. Gentleman who suffered an aneurysm on the job. He was working on the New Jersey Turnpike, just laying down cones, sitting on the back of the truck. You'd think, how in any way would that result to a brain aneurysm? What was failed to be provided to us as we got further into the case was that prior to him being on the back of that truck, he had been home having dinner, and prior to being home having dinner, he had already worked a 12-hour shift on a 100-degree day doing very heavy construction work and returned because the employer said, come back, you're working a double shift now. And came right back to that 100-degree day, and sitting on the back of the truck, that's when the aneurysm popped.
Right. And a vascular surgeon is going to say,
That's related.
Given this timeline, I would relate it.
It was enough, almost like a bridging symptom from a heart attack.
Right. Yeah. The timing is everything in the medical records. So Rich is going to take us to some other on-premises injury claims.
On-premises injuries, but sometimes the incidents that arise are purely personal in nature. So you have to look at what brought about the issue and dispute. On this one, we have Rosario versus the state of New Jersey, in which case the petitioner in this case had been assaulted by her ex-husband in the parking lot of the employer. Petitioner was trying to avoid the husband, had moved to a different location to get away from him, did not want any interaction whatsoever with her ex-husband, and mistakenly the employer provided the information, the receptionist there, to the ex-husband who tracked her down to the new employment place. The employer was well aware there was a danger present to this individual. There was a restraining order in place. They'd even offered security to this individual while she was on premises. And the question mark that arose was, because the assault occurred on premises, was it compensable? I was actually a little surprised by the result of this case, given the mistake made by the employer. But the holding from the court on that time was no, because the nature of the assault was purely from a personal relationship of the petitioner, it had nothing to do with her employment whatsoever, that it was not a compensable incident. And again, I think if the facts were cleaner, I wouldn't be as surprised by the decision. I think if the husband had simply tracked her down on his own and the assault had taken place, I wouldn't even think there'd be a chance of liability on the employer. I was a little surprised only because of the mistake made by the receptionist in providing that information with somebody who had a protective order out there and the employer was aware of it. But nevertheless, the court took a very firm line on it, indicating that this is, what brought about this assault was purely personal in nature to the petitioner. It had nothing to do with her employment. It could have happened anywhere where he tracked her down, and therefore not going to be a compensable loss.
You mentioned earlier about the identity of the respondent may be having an effect on the decision by the court. There's the state of New Jersey.
Yes.
So maybe again the fact that it's the state of New Jersey, not the deep pockets of a private company and a private carrier, that may have had an effect on it. And I don't know what happened subsequently. I haven't heard any case law on the issue or whether or not there was a subsequent suit about whether or not there was any type of direct action filed by her.
Civil liability against the employer. It's a possibility for a third party out of those facts.
Yeah, and I don't think we're saying anything that it's a surprise. Anybody would probably think of this anytime we discuss this case. People in the audience will always say to us, what about a direct liability action or failure to provide a safe workplace? So that's an issue for another day. It's not, but it wasn't workers' comp. And if she is able to file a suit, that's her call. the immunity for employers in New Jersey from civil suits is significant.
Yes.
But then again, this wasn't deemed to be workers' comp, so she doesn't have to pierce the immunity bar.
No.
So it would be a
There
matter.
very well could have been a liability claim that arose from this. The next one on that issue for disputes on premises was the Leslie Joseph case versus Monmouth County. Now, in that case, the petitioner was working as a nighttime nursing supervisor and attacked by a nursing assistant. Same thing. They look at the facts of the case and how it came about, the relationship and why the assault took place. Now, in this particular case, the injured worker had failed to replace money into a shared account that was shared among the employers, an accumulated fund account used by the other participants when necessary. And even though the fight took place on premises, again, the court looked very specifically about what brought about the assault, and they noted that the shared account, even though it arose out of the employment per se, I mean, it was set up through the employment, has nothing to do, they're not required to contribute into this account by the employer. It's a purely personal decision, and how they deal with their personal finances outside of work is not the employer's responsibility. So an assault that's going to arise out of a personal dispute over money that's not work money is not going to be something that's compensable.
Right. Yeah, the employer had nothing to do with this. They call it sue arrangement.
Yes.
I had to look that up, and
I didn't even know what it meant until I saw this case.
Yeah, it comes from like Ghana or a country in Africa that came up with this plan where people pool their assets together, and then when you borrow from the assets, I guess you do it interest free. I guess that's the benefit of it. But the employer had nothing to do with it. I mean, they may have permitted it.
Yes.
They didn't promote it. They didn't organize it. They didn't have anything else to do with it. It was just completely amongst the employees themselves. So, yeah, it was not deemed non-compensable. Yeah.
And again, just so you know, while we're not talking about any specific cases on it today, completely different circumstance, and we do see assault cases. I've actually seen them with nurses before where they'll get into a fight because somebody took somebody else's shift, or they might think they get a better rotation on the floor. It could happen with any employer, but those cases are compensable. And the fight itself, because assaults take place on premises, when the fight itself arises out of the employment and the employment relationship, completely different ballgame.
It is. Not a defense. So now let's move on to the off-premises injuries. So now we're not talking about the commutes, which we were talking about earlier. Is the commute over? Is the commute not over? Or the injury clearly takes place, or the disability clearly takes place on premises. Now we're talking about the off-premises injuries. And these cases are very fact-specific, and you need to get us as much information as you can for us to help you make a decision about compensability. And the general rule, as you probably all know already, is traveling employees have a much greater scope of employment while in the performance of their job duties off premises. So let's talk about some of the cases and get specific. The first one we're talking about is it's a famous case. It's a Supreme Court decision called Jump. And petitioner is a pumping station operator who inspects sites throughout the city of Ventnor, and thus he's on the road throughout the day. On the day of the injury, he went into work, and what he normally did is he would work from like 8 a.m. to 10 a.m. on the computer doing paperwork. He would leave the office at around 10, and the rest of the day he would spend on the road checking various sites that were part of his job duties in a Ventnor truck. So he's completely covered while he's during the course of his workday, unless, of course, he deviates, which unfortunately Mr. Jump deviated. So the facts reveal, while he was going from job A to job B, and on a map from job A to job B, he didn't deviate even a block. It was on the way,
route.
on the way from A to B, but he pulled the Ventnor truck outside of the post office. He got out of the post office and went in to get his personal mail. And so the argument from petitioner's counsel, who is now one of our fine judges, represented petitioners at the time, the judge said, this is a minor deviation. And one of the petitioner's witnesses, his star witness, was his supervisor. You'll see here at the bottom of the PowerPoint, the petitioner's supervisor testified, it's fine with me if these guys, while they're on the road, go and stop and get their personal mail. It's convenient. He didn't deviate. I don't know if he used the word when he testified, but he said, it's fine with me. He's stopping from A to B to get his mail. It's a couple seconds, no big deal. Well, fortunately, the Supreme Court said it was a big deal. The Supreme Court said that the effort to retrieve the personal mail during the course of the workday did not result in an injury that arose out of employment or during employment. The effort to retrieve the mail was purely personal, and it was a deviation from his job. So every step out of the Ventnor truck, walking towards the post office to get his personal mail, is a deviation, and he's no longer cloaked with coverage of employment. And we've discussed this before when we go over this case. If you change the post office, some of you may be wondering, to Wawa, or to a restroom, or to anywhere where you're going to get coffee, food, use the bathroom facilities, that's called the personal comfort doctrine. When people are at work, either on premises or off premises, we're all entitled to do those kind of things. We're entitled to get food and nourishment, water, coffee, etc. Your personal mail is not an entitlement to allow you to be able to function well throughout the course of your day. So that's the difference in the case law. Let me see. The next case we were going to talk about, the petitioner is a master plumber and foreman, and he's authorized to use the company truck for work purposes to and from his home. And he went to a job site, and then he drove to a union hall, and he had a meeting set up at the union hall. So in the facts of the case, he goes into the meeting room, and the individual with whom he was going to meet was talking to a group of people. And that individual waved him off and said, give me some time, I've got to finish my meeting. So what the petitioner did was he said, well, I've got time to waste, I'm going to go get some coffee. So did he go around the corner, across the street? Did he go half a mile away? No, he drove 5 miles to obtain his favorite coffee. And the respondent in that case presented a number of factual issues to the judge to try and have this found non-compensable, including the fact that he drove past a number of other opportunities to get that cup of coffee. And that as he was driving, he got closer and closer to a hospital where his ex-girlfriend was recovering from injuries. So they thought, he's going to get coffee and he's going to go visit his ex-girlfriend. And at that point, he's really kind of taken himself out of the course and scope of his employment. So the question is, did the court agree? The court did not agree. First of all, the court rejected the testimony of the now former girlfriend and said, accepted the petitioner's version of events that he had gone to this deli because it provided good coffee. I mean, even accepting that to me seems idiopathic. Yes. Coffee's coffee. You want to go 5 miles. Once you go past the first coffee shop, maybe you didn't see it, but the second coffee shop, you're no longer in the course of your employment. Getting your favorite coffee to me would have been purely idiopathic, but not according to the judge.
It's a bit of a stretch on the personal comfort doctrine, given these facts, but
yeah, the judge felt it was a minor deviation, but compared to the jump case,
who didn't even deviate off the line of where he was driving 5 miles out yet. It seems a bit. They seem in opposite of each other. It does not appear to make sense.
Right. And I was telling Rich this morning before we started, I was talking about a case yesterday where the individual left the employer's premises. I think it was a hospital setting where they have food on premises, but according to him, it's lousy food. So he would go across the street to get a sandwich because he said they made much better sandwiches. So yeah, I thought it was kind of similar. Favorite sandwich, good coffee. And he was shot during the course of a burglary. And his claim was denied, non-compensable, because it was a purely personal idiopathic off-premises injury to get his favorite sandwich, where he could have eaten on premises. So.
And having eaten at some hospitals, I don't blame them. So it's a little odd.
All right. So Rich is going to take us through some other issues of off-premises injuries.
We move into the special mission exception. And that's part of Section 36 of the statute, where we talk about when the employee is directed by the employer to be off premises in furtherance of the employer's business. So basically, they're not off doing their own thing. They're directly performing assignments provided by the employer at that time. So we have the Nemchik case, in which case we have a petitioner who is a supervisor whose normal job hours from 7 in the morning till 5 in the afternoon. But on this particular day, the petitioner was directed by the employer to travel to a place called Joanna Farms in Flemington, New Jersey, to investigate a problem with a shipment for the employer. They were advised to arrive there not during their normal hours, but to be there no later than 10 p.m. in the evening. Petitioner got there at 10 o'clock at night, as directed, before 10:30, and worked until 8 o'clock in the morning. On the way home from that assignment, stopped to have breakfast, which again would be falling under the personal comfort aspect of things, and after that, blacked out behind the wheel and had an accident. Now, the question falls on, is that compensable? Are they merely commuting at that time? The answer is no. This was not something this person normally did. It was not part of their normal routine. This was above and beyond where they're normally sent by their employers, not the normal place of employment, not their normal work hours. So yes, once that person left their house to head towards Johanna Farms in Flemington, New Jersey, till the moment they arrive home, or it could have been back to the office, either way, but until they complete that mission from door to door, everything that takes place during that assignment more or less is going to fall as compensable.
Yeah, it would have to be something purely personal.
Yes.
Like I went off the beaten path to see a relative, a friend, to pick up, something at Best Buy for my kid's birthday. That's different. And we look at these cases sometimes, and recently I've had some discussions in the office. Then the question is, at what point did they get back onto that road, back to the office or back home? Because at that point, I think the deviation has ended.
Yes.
But during the point in time where they actually leave the normal pathway back to their house or back to the office to do something purely personal, I think we would still have a jump issue.
I
Not this.
I agree. In this case, if it hadn't been the breakfast part and he had then stopped and went to get his mail somewhere,
Right.
while getting the mail, not compensable, but as Jeff pointed out, once he was done with that, if he got back on the highway that leads back to the same way to home that he would have been on anyway, I think it'd fall back under the compensability.
Right. But working from 10 p.m. to 8 a.m., we see a lot of these cases when people are asked to do something kind of above and beyond the call of duty.
Yes.
And it can cause exhaustion, hunger, et cetera. The judges are a little bit more, I wouldn't say liberal, but they're a little bit more compassionate about injuries that may take place due to fatigue, et cetera, which frankly makes sense.
I think you see it a lot more often too in things like the trucking cases, the instances where they're hauling freight overnight and they're under a deadline and under direction to have it there by a certain time. Those types of blackout accidents, and they happen, unfortunately, a little more likely to fall as compensable, even if they've deviated somewhat off the path.
A question that we get often is when people are off premises, they're off on an assignment for their employer, are they covered 24/7? And we can tell you the answer to the question, without making it unfun. The answer is, of course, no, they're not covered 24/7. But let's give you some specific examples.
But it's fact specific, like anything else. So
that's right. You got it now. Now fire away.
So are you covered for that 24/7 period? As we said, no, you're not. In the facts of the Manigan case, we have a petitioner who was employed as an investigator on a business trip with her supervisor. And at the end of the workday, following a workout, which I can appreciate, I like to do at the end of a workday, petitioner volunteers to buy food for her supervisor around 10 p.m. and goes out to McDonald's to get the food. On the way back from McDonald's, gets struck in the car. And the question is, well, out getting that food, you're off on a special mission, are those injuries compensable? The answer is no. The reason being, and the holding of the court really focused on, the workday itself had been completed by then. What they were doing at that time, whether it be working out or eating at that point in the evening, that's no longer even a personal comfort issue. These were just personal decisions, purely personal to these individuals, nothing in the furtherance of the employer. Nothing really played out there. It's a personal errand they wanted to do after the working hours. Now, there are exceptions to that as well. It's not this case, but we do see the cases where people are out on a business trip. You might be there. I actually handled one where the people were in London for business. At the end of the workday and meetings, they weren't, I'll say, required, but it was strongly suggested that they all attend a dinner for team building. While not mandatory, it was directed more or less. They wanted everybody to be there. While
Strongly encouraged.
Strongly encouraged. And while walking back from dinner in London, the person stepped into the street by mistake and was struck by a car. That case was deemed, I remember, as compensable by the court because, again, it wasn't a purely personal decision to run out to that restaurant at that point in time after the workday was completed. You were looking more realistically at an employer-sponsored event. And again, while not mandatory, that strongly encouraged aspect does make the court take a second look and say, well, really, you're there for team building as a dinner. You're encouraging everybody to be there. That would open up the door.
Right. Yeah, and in this case, had they attempted to gild the lily, I don't know if it would have worked, but they could have said we had to go over the next day's agenda, and we were starved, and we were going to have a meeting downstairs with our food. But I think it was they didn't gild the lily, and I think they
were very honest.
Work day was over. We had a workout. We were just hungry, and apparently, I'm sure there was food available on premises. But they decided to leave the premises. And at 10 o'clock at night, had it been earlier in the night, they might have had a better argument if it was dinner time and there was no food available. Because otherwise, if they were home, they'd be eating at home. Yes. But they had to leave the premises to get food. So the facts have changed a little bit. They may have prevailed. Similar to the case you're talking about in London, there is an unreported decision, but an interesting one where a young lady is with her boss, and her boss is basically saying, "Follow me while we schmooze these prospective clients. And so this is after hours. I think it's an off-premises, out of the city area convention. So they're going from event to event, party to party. And the night goes on and drinking continues. And her boss gets into fisticuffs. He gets into a fight, and she gets hurt in the melee. Well, she got benefits because at that point she said, I felt obligated to continue to follow him while we continued to hang out with clients, schmooze with them, get to know them better, have a good time with them, et cetera. So she was really caught in the fray of a brawl outside of a bar that her boss encouraged her to continue to follow him throughout the night. So
as we say, factual investigation in these cases is key to making determinations. And a lot of times it will fall on, I hate to say the term, but how well coached the witnesses is and how honest they're being as to what their actual activities and intentions were at that time.
Last case we're going to talk about. This is a case where the petitioner was on a work assignment in Australia, and he was encouraged to tour several popular locations while in Australia, because the employer was hoping that the petitioner would want to relocate to Australia for a longer-term assignment. So they had some skin in the game. They had a vested interest in this petitioner enjoying the trip, liking Australia, and wanting to stay longer. So they said, here's some brochures. Why don't you go do some sightseeing? So the petitioner took one of the recommended trips while sightseeing and suffered fatal injuries. If you just gave me those facts,
I would have said compensable.
I would have said probably compensable. The court disagreed, and the question was whether or not the injuries suffered on the business trip were compensable, and the court said no. At the time of the fatal injuries, the petitioner was not engaged in the furtherance of his employer's business interests, but a personal sightseeing pursuit. I think it was a little bit of both.
It's a gray area there.
It certainly was personal sightseeing, but the idea is the employer really wanted him to take advantage of this and to enjoy the trip and say, I will move my family to the other side of the world to further my employer's business interests.
When Jeff and I talked about this one, we both kind of agreed that we were surprised by the holding of this case because it certainly falls in that area we were talking about before, the notion of being strongly encouraged to do things by the employer, and that normally opens the door up for compensability. In this case, more than strongly encouraged, they gave this gentleman a list of places to sightsee at, and he took them up on the ones they recommended to him. This happens to be one of the ones they told him, you should go see this site.
If any of you are friends with petitioners' attorneys, don't tell them that Rich and I weren't so sure that this was the right decision. We don't want to ruin our reputation.
No, it's just, but it is one of those gray areas are tough.
So in general, course and scope of employment injuries, they require intense factual investigation. So when you come to us with a question by phone or by email, we're probably invariably going to follow up with you with more detailed investigation necessary, more facts in order for us to give you an opinion. The off-premises injuries, that's a timeline, that's a location, mapping things out. The on-premises injuries are going to be generally more difficult to defend because injuries that occur on premises, unless somebody is struck on the head by a hammer by a co-employee because they're not giving up money to an employee pool of money, those are tougher to defend. And if we're arguing that a physical injury, for instance, or a heart attack or stroke are not work-related, it is our burden to prove that it is idiopathic or purely personal. And if the employee says this happened during work hours, they're usually a leg up on us, and we have to do the investigation to prove that it was purely idiopathic and not a risk associated with the job.
And I would add, when we talk about it requires intense factual investigation, I would add into that time-sensitive investigation. Before stories can change or things get changed, you want to assume the best in people, but before stories and facts can be changed to fit the mold of what might work, you really want, when you have one of those, especially in off-premises injuries, you want the statements as soon as possible after the incident takes place, when it's contemporaneous and fresh in the person's mind, any witness's minds, that they can give you the facts as they recall them before anything, as you would say, gild the lily, before anything can be changed to fit a set of facts that would be more beneficial to a party.
Well, thank you very much for attending the webinar. I wanted to let you know that our next program is July 26th, and that's going to be from the Philadelphia office. And that's entitled Going Beyond the Handheld Camera, Effective Investigation in 2016. So our partners in the Pennsylvania Workers' Compensation Department are going to be talking about the use of social media investigation, private investigators, how to get that into evidence, how to avoid any ethical issues that may arise, because sometimes that does happen. Don't friend the injured worker in order to find out information about them under a subterfuge. That's not a good idea. So, and again, if you have any questions, send them to The questions, where I told you at the beginning, questions at wglaw.com. And Rich and I'll be happy to answer them today.
Yes.
And again, thanks for listening in, and hope you enjoyed it. Have a great afternoon.
Thanks for joining us.